Okay, we're on a record in two cases. First case is cause number 325-650. Cases, and the second case is cause number 325-652. Both cases are style of State of Texas versus Lindsay Ross LaForte. Is that your full name? How are you doing, Ms. LaForte? That's good. Ms. LaForte, you're here represented by your attorney, Mr. Nathan Reynolds. Mr. Reynolds, how are you doing?
Doing well, Judge. How are you?
I'm doing fine. Thanks for asking. Mr. Reynolds, you have an announcement you'd like to make in this case?
Yes, Judge. We've requested a trial. We've received an offer in both cases and also discovery.
Okay. Hold on a minute.
Are you wanting me?
Yes. You'd like to have on a trial docket?
Yes, sir, Judge.
Okay, could you give us a trial date on Miss Lindsay LaForte's case?
Hold on, Judge. It's quite busy. July 26th, and I'll have your resets in the back.
Okay. Case gonna be reset for trial July 26th.
Yes, sir.
Mr. Reynolds, you can get your reset from the court coordinator in the back office. And Ms. LaForte, once your attorney give you a reset, you'll be free to go and you have a blessed day. Okay.
About community service. Is it being waived?
It's been waived.
Okay, could you note it on there and just, I can,
We're on a record in cause number 323-139, case is style of State of Texas versus Hector Christeny. Okay, for the record, is your name Hector Christeny?
Crisanti.
Crisanti.
Yes, sir.
Okay, how you doing, Mr.
I'm
Crisanti?
great, thank you, sir.
That's good. Mr. Crisanti, you're here represented by your attorney, Mr. Jerry Gilthorpe. Mr. Gilthorpe, how are you doing?
Doing well. How are you?
I'm doing fine. Mr. Gilthorpe, your case is set on the court's trial docket. What is your announcement?
We're ready for trial, Judge.
Okay, now this is not one of our scheduled trial weeks from our administrative judge, so we're gonna have to give you a date that's consistent with the order that we got from the administrative judge.
Okay.
Okay? Now, I see a note on the docket sheet that Mr. Christian, he has a DWI second. He was required to get a interlock. Do you know if he got that interlock?
I don't believe he.
No, no, no.
I don't believe he was ordered to have it unlocked because he blew it.
It's a DWI second. It's not based on the breath test. It's based on the court's outstanding order, and pretrial order that we give in all DWI cases. Okay, let me do this here. they're gonna need a reset too for trial. And this is Hector Christine. You can pass that to him. I'll go over it. Okay, Mr. You pronounce it Christine or Christani?
Crescenti,
Chrisanti?
Crescenti, yes, Italian.
Chrisanti, okay. Mr. Chrisanti,
Yes, sir.
the document that's been handed out to you is titled Standard Bond Conditions in County Court at Law Number 2. Do you see that do you have that document? That's the title.
Yes, sir.
Okay, I'll go over this document with you. And it reads, following the arrest and/or accusation in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named here or ordered subject to the following additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes, sir.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court, and the court may revoke the bond and order the arrest of any defendant who, A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body, and that's pursuant to the Texas Code of Criminal Procedure, Article 17.44, Section A2 and Section C2. Do you understand that condition?
Yes, sir.
Now, condition number 3 actually doesn't apply in this case, so I'll go to condition number 4. Condition number 4 states that, and this deals with individuals who have DWI charges, and the charge is either a DWI second or more. Your case is a DWI second. Okay, so I'll go over this condition with you. It says a defendant who has been arrested or accused of any subsequent offense listed under section 49.04 through 49.06 of the Texas Penal Code shall not operate any motor vehicle unless the vehicle is equipped with an interlock device mechanism that makes impractical the operation of the vehicle if ethyl alcohol is detected in the breath of the operator, and said device shall be installed at the defendant expense with written verification of such installation being submitted to the court on or before the 10th day after arrest. And so instead of saying the 10th day after arrest, because we're far beyond that, we're gonna say the 10th day after today. And may I see your, so I can make that change? Now, do you understand that condition?
Yes, sir.
Okay. Yeah. Okay, so your attorney can provide you with proof. Well, you could provide proof to your attorney, and your attorney can get it to the court. Okay?
Yes, yes, sir.
All right. So just wait around. She's gonna give you your reset.
Okay.
And once you get your reset, you'll be free to go, and you have a blessed day.
Thank you. Have a blessed day, sir.
Okay. Okay, I got it. I have another one for him. Oh, that one's already reset? No, this one is reset. Who we have ready? This is Marvin Wilson. Okay.
This is this one. I just wanted to give you a heads up so you know. Oh.
We're on a record in cause number 321-752. The case is style of state of Texas versus Marvin Wayne Vincent.
Mr. Vincent, you can close, please.
Mr. Vincent, would you please raise your right hand? Mr. Vincent, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
You may put your hand down. How are you doing, Mr. Vincent?
You know, fucking yourself.
I'm doing fine, thanks for asking. Mr. Vincent, you're here represented by your attorney, Mr. James Paget. Mr. Paget, how are you doing?
Doing well. Good morning, Your Honor.
Good morning to you as well. Mr. Vincent, the information in this case alleges that on or about November 11 of 2018, while you were in Jefferson County, Texas, you committed the Class A misdemeanor offense of criminal mischief. Mr. Vincent, do you understand what you've been charged with?
Yes, sir.
And to this charge, Mr. Vincent, how did you plead guilty, not guilty, or no contest?
Guilty.
Now, are you pleading guilty freely and voluntarily? Are you pleading guilty freely and voluntarily?
What you mean by that?
Is anybody forcing you to plead
No, sir.
guilty? Okay. And are you pleading guilty because you're guilty?
Because I'm guilty.
Okay, Mr. Vincent, I have before me a document that is titled the misdemeanor. The misdemeanor plea admonishments. This document is also labeled as State's Exhibit Number 1. Mr. Vincent, do you recognize this document?
Yes, sir.
Okay, on page 2 of this document, Mr. Vincent, there's a set of initials online that says guilty. These initials are MV. Did you place your initials on this document?
Yes, sir.
On page 3 of this same document, Mr. Vincent, there's a signature above the line that says defendant. Is that your signature?
Yes, sir.
And on the next document, which is the trial court certification of defendant's right of appeal, do you recognize this document?
Yes, sir.
And is this your signature above the line that says defendant?
Yes, sir.
There are 2 boxes that's checked at the top of this document. The first box states that this is a plea bargain case and you have no right of appeal. Do you understand that?
Yes, sir.
The second box states that you are waiving your right to appeal, which means you're giving up your right to appeal. Do you understand that?
Yes, sir.
I also have a document here that is titled the discovery certification. You recognize this document?
Yes, sir.
And is this your signature above the line that says defendant?
Yes, sir.
Mr. Vincent, prior to signing and initialing all of these documents that we just mentioned, did you have an opportunity to read these documents?
Yes, sir. As I was signing, I did.
Okay, and did your attorney go over these documents with you?
Yes, sir.
And did you understand everything that you read?
Yes, sir.
You understood everything that your attorney went over?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
State, I have before me State's Exhibit Number 1. State, you like to offer State's Exhibit Number 1?
Yes, Your Honor.
No objections to stage 1, Your Honor.
Okay. No objections. State's Exhibit Number 1 will be admitted. Mr. Paget, you advised that counsel, Mr. Vincent. Is there any evidence that he is currently mentally incompetent to stand trial?
No, Your Honor.
Mr. Vincent, your attorney, Mr. Paget, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided fully effective and competent legal representation?
Yes.
Okay, Mr. Vincent, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I'll also find that your plea of guilty and waivers was freely and voluntarily given. I'll also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, Your Honor. It's for 6 months deferred probation, a $100 fine, and restitution in the amount of $843.27 paid to Natalie Vincent.
and the state is waiving community service.
Yes, Your Honor.
Okay. Okay, Mr. Vincent, the state. Okay, the state is offering that you serve, that you be placed on probation, deferred adjudicated probation for 6 months. During the 6-month probationary period, you'll be required to pay a fine of $100 plus court costs of $337, which comes to a total of fine and court costs of $437. You'll also be required to pay restitution in the amount of $843.27 payable to Natalie Vincent. You'll also be required to pay probation fees of $60 each month, a urinalysis fee of $15 each month. And this will come to a total of monthly installments of $335. Mr. Vincent, will you be able to pay the $335?
How much?
It's 300 and, that's what it says, $335 a month. Most of it doing. Yeah, it's $335 per month. Would you be able to pay that?
I can try to, but if it be a case that I can't do it that month, would it be a problem or?
Well, I mean, you just have to let me know now, will you be able to pay it or not able to pay it? And then we'll go from there.
No, I'm not gonna go try to lie to you.
Okay, so you're not able to pay it. Okay, so let's see, the court costs. Okay, the restitution is $843. Okay, let me do this. Everyone who's on Zoom, make sure that your mic is on mute. And then when we call your case, we'll have you to take it off mute. Thank you. Okay, now, Mr. Vincent, I need to get some information from you. Mr. Vincent, are you employed?
Yes, sir.
And where are you employed?
For the county, well, not actually for the county, through from a temp service through the county.
Okay. I'll say yes. So what's the name of the, you said, it's, I guess, through Jefferson County, but, and how many hours a week you work?
8.
A week?
Oh, not a week, 40. I said.
Oh, okay. And you married, single, divorced, separated, widow? Single?
Yes, sir.
Okay. Now, what is your, let me do this here. Pursuant to Article 1.24 of the Texas Code of Criminal Procedure, all proceedings and trials in all courts shall be public. However, pursuant to Lilly versus State, 365 Southwest 3rd, 321, the right of public trial is not absolute and may be outweighed by other competing rights and interests such as non-public information, preventing non-public information, or the interests of security, or ensuring that the defendant receives a fair trial. So, Mr. Paget, are you opposed to this hearing, this portion of the hearing being closed because there may be, well, to prevent the disclosure of non-public information such as his income information?
I'm not opposed to that being a closed hearing, Your Honor.
Okay. The court is going to find that the parties seeking to close the hearing have advanced an overriding interest that is likely to be prejudiced toward the defendant. The closure is no broader than necessary to protect those interests, and the court has considered reasonable alternatives to closing the proceeding, and the court finds that the finding is adequate to support the closure. So at this time, the audio portion of this hearing will be closed.
There you go.
All right, I'll put it on mute. When it's time for them to talk to you, then you are.
Yes, yes, should I make it down Friday? I said, yeah. No, I don't know. You can hear me now? I can't hear you.
And then once we get the judgment, we'll read the judgment out and then.
I need a judge now.
You're on mute. I mean, everyone who is on Zoom, make sure that your mic is on mute. And that's Mr. Eric Richard.
Yes.
Make sure your mic is on mute.
Let's put that mic on mute. Mute. Make sure your mic is on mute. Okay. Okay, thank you. Okay. Now we're back on the record in cause number 321752. The case is filed with State of Texas versus Marvin Wayne Vincent. We have Mr. Vincent present in court with his attorney, Mr. James Paget. We also have present the State Assistant District Attorney, Mrs. Maxey, and Mr. Vincent. The state is offering that you serve 6 months deferred adjudicated probation. During this 6 months adjudicated probation period, the state is offering that you pay a fine of $100 plus court costs. And pursuant to Article 42.15 of Texas Code of Criminal Procedure, the court is going to convert $250 of your court costs into 20 hours of community service. Now, you will also be required to pay restitution in the amount of $843.27 payable to Natalie Vincent. And you will also be required to adhere to the other standard terms and conditions of probation. Now, the the state was not offering community service in this case. However, the court has converted $250 of your court costs to community service. Do you understand the state's offer and the court's judgment?
Yes, sir.
And do you think that the state's offer and the judgment is fair and just?
It is.
And do you accept the state's offer and the judgment? Okay. I'll follow the plea bargain agreement that you've entered into with the state. Mr. Vincent, Mr. Vincent, if you successfully let me do this here. I didn't mention to you what the amounts is that you have to pay. The court cost, the fine is $100. $100 court cost is $437, and $250 of that will be converted into community service. Now, the restitution in this case is $843.27. You will also be required to pay probation fee of $60. And like it came out to be the same amount.
Yes. Probation officer.
Oh, they're gonna make the adjustments. Oh, okay. And so, the urinalysis fee is, $15 each month. Now, the judgment states that you're finding your monthly installments is $335. However, when probation see the fact that $250 of this is converted into 20 hours of community service, they will make the adjustment on how much you're gonna pay per month. Do you understand that?
Yes, sir.
Now, do you think that the state's offering and the court's judgment is fair and just?
It is.
And do you accept it?
I do.
Okay, I'll follow the plea bargain agreement that you have entered into with the state. Mr. Vincent, stand over here. Okay, let me tell you this here, Mr. Vincent, if you successfully complete the probationary period, this case will be dismissed. It will not appear on your record as conviction, and you may qualify for non-disclosure. You can check with your attorney. He's quite competent in these matters. He can tell you about how to go about applying for non-disclosure. All right, you can stand on the X, follow the directions of our court clerk, and once you finish following those directions, you'll be free to go, and you have a blessed day.
You too. Thank you.
Okay, Miss, you have another plea? Okay. That's guard. Oh, well, just doing my job. That's what the rules say.
I appreciate it.
We're on a record in clause number 327-858. The case is styled the state of Texas versus Fillmore Gart. Mr. Gart, is that your full name? Would you please raise your right hand, Mr. Gart? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth so help you God?
I do, y'all.
Okay, you may put your hand down. How are you doing, Mr. Gart?
Okay, brother.
That's good. Mr. Gart, you're here represented by your attorney, Mr. Pageant. Mr. Gart, the state is also here represented by Mrs. Ramos, Assistant District Attorney. Mr. Gart, the information in this case alleges that on or about August 19 of 2020, while you're in Jefferson County, Texas, operating a motor vehicle in a public place, that you committed the Class A misdemeanor offense of driving while intoxicated with an alcohol concentration level of 0.15 or more. Mr. Gart, do you understand what you've been charged with? You understand what you've been charged with?
Yes, y'all.
Okay. And the reason why I told you to speak up is because she's typing it down, so she needs to hear you. Now, to this charge, Mr. Gart, how do you plead? Guilty, not guilty, or no contest?
No contest, y'all.
Now, are you pleading no contest freely and voluntarily? Are you pleading no contest freely and voluntarily?
Really, so.
Okay. And are you pleading no contest, Mr. Gart, because you do not wish to fight or contest the charges? Okay. Miss, you need some time to talk to your,
No, he just didn't understand your question.
okay, are you pleading no contest because you do not wish to fight or contest the charges?
Do you want to fight this case?
No, Your Honor, no.
Okay, so that's why you pleaded no contest, is that
Yes,
correct?
ma'am.
All right. Now, Mr. Gort, I have before me a document that is titled the Misdemeanor Plea Admonishments. Do you recognize this document?
That's the one we just reviewed.
Yes, Your Honor.
Okay, on page 2 of this document, Mr. Gort, there are a set of initials on, the initials of PTG, and they're on a line that is checked, no contingent, which means no contest. Did you place your initials on this document?
No contest.
I know. Did you place your initials on this document?
Yes.
Okay. And at the top of this document, Mr. Gort, there's a signature above the line that says defendant. Is this your signature?
Yes, Your Honor.
Okay. And on the next document, which is titled the Trial Court Certification of Defendant's Right of Appeal, Mr. Gort, do you recognize this document?
Yes, Your Honor.
Is that your signature on the line that says defendant?
Yes, Your Honor.
There's one box that's checked at the top of this document. This box states that this is a plea bargain case and you have no right of appeal. Do you understand that?
Yes, I do.
Okay. I also have a document here that is titled the Discovery Certification. Do you recognize this document?
Yes, Your Honor.
And is this your signature on the line that says defendant?
Yes, Your Honor.
Now, prior to signing and initialing all of these documents that I just mentioned, did your attorney go over these documents with you?
Yes, Your Honor.
And did you read these documents?
Yes, Your Honor.
And did you understand what you read?
Yes, Your Honor.
And is everything in these documents true and correct to the best of your knowledge?
Yes, Your Honor.
Okay. State, I have before me State's Exhibit number 1. State, you like, oh, I also have State's Exhibit number 2 as well. State, you like to offer State's Exhibit number 1 and 2?
Yes, Your Honor.
No
Any
objections to stage 1 or 2.
Okay, no objection. State's Exhibits number 1 and 2. Mr. Patrick, you advising counsel, Mr. Gort, is there any evidence that he's currently mentally incompetent to stand trial?
None, Your Honor.
Okay, Mr. Gort, your attorney, Mr. Paget, has advised and counseled you. Are you satisfied with his representation?
Yes, Your Honor.
Has he provided full, effective, and competent legal representation?
Yes, Your Honor.
Okay. Mr. Gort, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea of no contest and waivers were freely and voluntarily given. I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, Your Honor. It's for 1 year to be probated over 2 years, $1,500 fine, 100 hours community service, DWI education, drug and alcohol assessment, the intervention program, and an interlock.
Okay. Okay, Mr. Gort, the state is offering that you serve 1 year in the Jefferson County Jail. However, you will not have to serve any time in the Jefferson County Jail because you'll be placed on probation for 2 years. During the 2-year probationary period, Mr. Gort, you'll be required to pay a fine of $1,500 and court costs of $307, which comes to a total of fine and court costs of $1,807. You will also be required to pay $60 probation fee each month and a urinalysis fee of $15 each month. You will also be required to pay the Jefferson County DWI education class an initial evaluation fee of $125 on the day of the plea. If a further evaluation is needed, you'll be required to pay an additional $50. Now, the total monthly installments for this case is $155 a month. Mr. Gort, would you be able to pay the $155 per month?
Yes, Your Honor.
Okay. Now, Mr. Gort, you will also be required to perform $100 of community service, attend the DWI education class and drug assessment, attend the DWI intervention class, and
you will be required to install a DWI interlock device on any vehicle that you own or operate. You will also be required to adhere to the other standard terms and conditions of probation. Mr. Gort, do you understand the state's offer?
Yes, Your Honor.
And do you think that the state's offer in your case is fair and just?
Yes, Your Honor.
And do you accept the state's offer?
Yes, Your Honor.
Okay, Mr. Gart, I'll follow the plea bargain agreement that you have entered into with the state. Mr. Gart, you're gonna stand on the X, you're gonna follow the directions of our clerk. And once you finish following those directions, you'll be free to go and you have a blessed day.
Thank you, Your Honor.
Okay, you're welcome.
Your Honor,
Get posted right
I
down.
have one more.
I believe she was, Your Honor.
There, young lady.
Okay, we're on the record in cause number 326534. The case is styled the state of Texas versus Francis Morrell. Is that your full name?
Yes, sir.
How you doing, Ms. Morrell?
Just fine.
That's good. Mr. Morrell, you're here represented by your attorney, Mr. Paget. This case is on the trial docket, and then, as I previously mentioned, this is not one of our scheduled trial weeks from our administrative judge. So, Mr. Paget, you have an announcement you'd like to make?
We just would like to keep it on the trial docket, Your Honor, and Miss Maxey's defense, I've just had an opportunity to speak
Okay.
with her about it at the end of last week, so
That's
it
fine.
was just dumped in her lap, and I assure you that I'll,
Well, yeah, she's been here, this is your third week?
I think this is the beginning of my fourth.
Fourth week, okay,
I'm still coming back.
okay. Ms. Smith, could you give us a trial date for Francis Morrell?
September 27th.
Okay, case gonna be reset September 27th. Mr. Paget, you can get your reset from our court coordinator. Once you get your reset, you'll be free to go. And Ms. Morrell, once you get your reset from your attorney, you'll be free to go, and you have a blessed day.
Thank you,
All right. All right, thank you. Who else do we have? Okay. I'm not in court. Yeah. We did look forward. Let's see, District Harold Reynolds. Mr. Reynolds, did your client Gidria appear?
Mr.
Miles Gidry?
He's present, Judge, yes, sir.
Okay, won't you, Mr. Bailey, could you call the name of Miles Gidry? He's on the, he's at the bottom of page 1 of the announcement docket, Miles Gidry. Okay, we're on the record in cause number 324552 and cause number 324554. Both cases are styled the state of Texas versus Miles John Gidry. Is that your full name?
Yes, sir.
Okay, how you doing, Mr. Gidry?
Good about yourself.
I'm doing fine. Thanks for asking, Mr. Gidry. You're here represented by your attorney, Mr. Nathan Reynolds. Mr. Reynolds, how are you doing?
Doing well, Judge.
That's good. Mr. Reynolds, do you have an announcement that you'd like to make in this case?
Yes, sir, Judge. We have received an offer from the prosecutor and discovery in both cases. We'd ask that these cases be placed on the trial docket.
Reset, okay. Just hold on a minute. Our court coordinator will give you a reset date.
They sound muffled. Is he saying a trial setting?
Yes, he wants the trial setting.
9/27.
Okay, it's gonna be reset to to September 27th of 2021. You can get your reset from the court coordinator. Once your attorney give you your reset, you'll be free to go and you have a blessed day. You could just have a seat.
Morning, Judge.
Good morning. Could you put your mic on mute when we call your case? We'll call you back up. Let's see, we have Miss Trill. Dustin Galmore's is not here. Okay. Okay, yes,
Could we deal with this, because she's got a warrant, and
okay. Who,
she's not on, her name is Randy Johnson,
she's not on the docket?
bond forfeiture from last week.
Oh. Okay. Hold on a minute. Mr. Freeman, do you have a case? What? Okay.
Timothy Besser, there, is there?
Yeah, and Timothy Besser's in custody and has a felony case.
Right.
Oh, so he's already, oh, so with that case is gonna be reset with the felon, with
Yes.
the felony.
Yes, Your Honor.
Okay. Who else?
Hope.
Then we have Jacoby Hope. We have.
Hold on a minute. Let me, what document?
Mr. Hope is on the plea docket, Your Honor.
Trial time? Oh, that,
No, plea, he was set for plea today. He had a fine and court cost.
is Hope, once you get Mr. Hope,
Toby Hope. Toby Hope.
okay, We're on the record in cause number 326860. The case is styled the state of Texas versus Jacoby. Is that Deontay
Yes, sir.
Hope? Mr. Hope, how are you doing?
I'm doing fine. How you doing?
I'm doing fine. Thanks for asking. Mr. Hope, you're here represented by your attorney, Mr. Antoine Freeman. Mr. Freeman, how are you doing?
I'm good, Your Honor.
That's good. Mr. Freeman, you have an announcement you'd like to make in Mr. Hope's case?
Yes, Your Honor. It was set for, on the plea docket today. We need a little more time to come up with the funds.
How much time does he need?
I just need probably 3 weeks. This is, sir. I promise. Cause my,
Okay, we'll give you 4 weeks.
cause my dad told me when they had everything. I
That's
had
fine.
A deal right on my birthday. My birthday was on Cinco de Mayo. They pulled it to us. Once you win, you should. I'm sorry, but I'm trying to.
Okay, so we're gonna give you, we're gonna give him a month.
That's fine.
Okay, that'd be enough time?
That's all I need. Thank you.
That's fine, that's fine. Miss,
That'll be 6:16 on the announcement docket.
okay, we're gonna be on 6:16 on the announcement docket. Mr.
Could you ask Mr. Freeman to come and get his reset, please?
Freeman, you can get your reset. And once you get your reset from your attorney, Mr. Hope, you'll be free to go.
Okay, thank you.
All right, you have a, just go have a seat on one of those chairs out there with the white tag on it.
Yes, sir.
All right, and you have a blessed day.
Thank you too.
All
Thank
right.
you, Your Honor.
Yeah, she's in the, you gotta go to her office.
Yeah.
Is that Mr. Bynum?
Yes, yes, Kimberly Brown.
Who?
Yes, Kimberly, may I approach her?
Yes.
Kimberly Brown. She's outside.
Would you please call the name of Kimberly Brown? Okay, we have a couple of folks on the on Zoom that we're gonna get to next. We're on the record in cause number 327338. The case is styled the state of Texas versus Kimberly Suzanne Brown. Is that your full name? How you doing, Ms. Brown? You doing okay? Ms. Brown, you're here represented by your attorney, Mr. Christopher Bynum. Mr. Bynum, how are you doing?
Doing well.
Yes.
Yourself, Your Honor?
I'm doing fine. Thanks for asking. Mr. Bynum, you have an announcement you'd like to make? Ms.
Yes, Your
Brown?
Honor. That's a JP reduction.
Oh, okay.
And Ms. Brown and I have had some communication, telephone issues. She's going to go over to the JP court after this and take care of that.
Oh, it's already been called in?
Yes, Your Honor.
Okay.
Yeah, Ms. Ramos took care of it. So.
Okay, so what we'll do is, she's gonna take care of that today.
Yes.
Miss, do we know what JP it is? Is it one of the JPs?
Place 1, Court 2, I think.
Oh, that's here, that's
Yes,
downstairs.
Your Honor.
Okay, well, she's gonna go, we could allow her to go do that right now, then when she finishes, she could just come back up and show us the receipt.
Okay.
And then the
very good.
state will do what they, has offered to do.
All right.
Okay.
Take care of it.
All right. JP reduction. Is it, the case on the docket?
No, sir, it's not.
Okay, I'm just trying to get to the ones. Your thought. Do we have another one for you?
Yes, Judge, Mr. Robert Doucette.
Okay, would you call Robert Doucette?
He's present, he's in the office.
Oh, see what I missed. I put the one mark in the wrong spot. And I had it, yeah. Okay, we're on the record in cause number 325289. The case is styled the state of Texas versus Robert Lee Doucette. Is that your full name?
Yes, sir.
How you doing, Mr. Doucette?
I'm good, sir. Yeah.
I'm doing fine. Thanks for asking. Mr. Doucette, you're here, represented by your attorney, Mr. Jared Gilthorpe. Mr. Gilthorpe, you have an announcement that you would like to make in Mr. Doucette's case?
Yes, sir, we're ready for trial.
Okay. Our cases is, this is not one of our trial weeks, and so we can, get a trial date. Ms. Smith, could you give us a trial date? Ms. Smith, could you give us a trial date on Robert Doucette?
Just a second, sir. I have someone in the office as well. I'm sorry, Judge, who is it on?
Robert Doucette.
Robert Doucette. 9/27 for trial.
Okay, we're gonna get you, gonna be reset to, September 27th for trial. Once you get your reset, you'll be free to go and you have a blessed day. Mr. Gilthorpe, you can go in the back and get your reset.
Thank you, Judge.
All right. Is this your last one?
That's all I've got today.
All right, you have a blessed day as well. Okay, I thought I saw Mr. Delmore. Let's see, we got Eric. Let's see, we got Latoya Trailer, Eric Richard. Okay, yeah, I see who is the, that's Eric Richard, okay. Okay, we're on a record in cause number 325314, the state of Texas versus Eric Dwayne Richard or Eric Dwayne Richard. Mr. Richard Richard, you can turn your mic off of mute, and you're here represented by your attorney, Mr. Bruce Cobb. Mr. Cobb, how are you doing?
I'm doing fine, Your Honor. I've got to try to tell Eric to unmute.
Okay, Mr. Richard, you can take your mic off of mute. Okay, it's off. Okay, Mr. Richard, how are you doing?
Good.
You're doing good. Okay, Mr. Cobb, you have an announcement you'd like to make in Mr. Richard's case?
We'd like to possibly plead at a recent later date, if that's possible.
How much time do you need?
Can you give us 30 days? We may be able to plead it like on Friday or something, but if you can give us 30 days, that would be fine.
Okay, now you want 30 days. You want it on a Friday?
Well, if I could plead them on a Friday, it'd be better for right now because of my transportation system.
Okay.
I can come to Beaumont on Fridays. That may change, but for right now, if we get 30 days, that'll give us a lot of lead time. We could plead him anytime between then.
Okay, we'll put him on a Friday. We give him 30 days. Hold on for your reset.
It'll be 6/25 on an announcement docket on a Friday.
Okay, it's gonna be reset to June 25th. That's a Friday. Mr. Richard, your case is being reset to June 25th. Stay in contact with your attorney. This will conclude your case. You're free to go, and you have a blessed day. And Mr. Cobb,
You too.
make a note of this date, and
Right.
notice of this date as well. And Mr. Cobb, I think, is this your only case?
I'm not sure, Your Honor. I think I have another one, but
Okay, just hold on there. Put
okay.
your back on mute, and we'll look for that one.
Yes, sir.
Okay.
any other, Bruce?
I'll tell him. Okay, Mr. Cobb, there are no, that was your only case. So you're free to go as well, and you have a blessed day.
Thank you, Your Honor. I appreciate that
Oh, you're welcome.
too. Thanks.
Mr. Doyle,
Yes, sir.
you like to come forward?
Yes, sir.
You can come forward. That's your client?
Yes, ma'am. Oh, yes, sir.
You can have your client to come forward too. I don't know. This case was not on the court's docket. What's your client's name?
Randy Johnson.
Randy?
Mhm.
Is that R-A-D-I?
It's cause number 318-262, Judge.
262. Okay,
Right.
Randy Johnson. Okay. Okay. Okay, now, Mr. Doyle,
Yes, sir.
you want to go forward?
Yes, sir.
Okay.
What happened is that on Monday of last week, Ms. Johnson is presently residing in Dallas, court appointed. So she contacted me on the weekend before the court date and wanted to know if there would be a problem with doing it the following week because she was getting some friction from her boss at her place of employment in Dallas. And I said that I didn't think there'd be any problem with that because it would only be resetting it a week, but there was no time to phone in anybody. So
You
she
didn't tell her she can appear by phone or Zoom?
Well, I didn't tell her about Zoom because I never think about Zoom.
She could appear by phone or Zoom. She didn't have to appear in person.
Well, that'd be my ignorance. 'Cause I
Well-
don't ever think about it.
Well, I mean, we've been doing this for the last couple of months. But she, what day? That was the 3rd, right?
Yeah, the days, yeah, I think. 9th, 8th, yeah.
Yeah.
Just by the records, I'm the 3rd or 4th attorney that she's had. And she's come to court all the time as before.
Yeah, I think she's bailed out by Bail Americas too. Yeah. Yeah.
So the choices are to the court is that she either go to the jail and you set a new bond, or you recall the warrant under the circumstances, because it's really not her fault.
Well, I mean, she had a bondsman. I mean, you're not a bondsman. Where's my, hold on a minute. Okay. Okay, you have anything else?
No, sir, we either ask you to recall the warrant or set a bond.
Yeah, okay. The, state, you have anything?
No, Your Honor.
Okay. Court is, not gonna recall the warrant. What was the bond set at?
I don't know.
No, I'm talking to. I need to get the, information, look at the bond.
The original bond was $750.
Yeah, okay. I need to look at the, well,
You want the bond?
let me do this here. Print off. From you. Let's see. Okay, now, Ms. Johnson, do you live in, let me see, it's got the facts. Yeah. Now, Ms. Johnson, I don't need to know your address. Do you live in, just tell me what city and state you live in?
It's Texas.
Which,
County.
oh, you still live in Cook? Okay, because that's, okay, I have that here. Okay, born in, Beaumont. Okay, now, now is this, I see as far as, criminal history, you just have this, this theft case that's pending, that's it?
Yes, sir.
You never been in trouble before?
No, sir. Traffic ticket.
Okay,
She had a intoxication too, but
that's class C.
Yeah.
Yeah. Okay, so no felonies, no misdemeanors other than class Cs. And you just have this case that's pending. And this is a, okay. Okay, that's community safety. Planning safety. You ability to make a bond. Are you employed?
Yes, sir.
Okay. And, let me do this here. Pursuant to Article 1.24 of the, Texas Code of Criminal Procedure, and pursuant to Lilly versus State, I need to access some information that may be non-public. So pursuant to Lilly versus State 365 Southwest 3321, Mr. Dole, the court is considering closing this portion of the public trial. We do know that Article 1.24 states that the proceedings and trials in all court shall be public. However, pursuant to Lilly versus State, the right to a public trial is not absolute and may be outweighed by other competing rights or interests such as interest in security, interest in security, preventing disclosure of non-public information, or ensuring that a defendant receives a fair trial. Now, Mr. Dole, I have some questions that I need to ask to set the bond, and that information may be non-public information. Are you opposed to this portion of the hearing being closed to allow the court to get the public, that non-public information from your client?
We don't have any objection.
Okay. So pursuant to Lilly versus State, the party finds that, well, the court finds that the party seeking the closure of the hearing have advanced an overriding interest that is likely to be prejudiced. And two, the closure is no broader than necessary to protect that interest. And three, the court have considered reasonable alternatives to closing the proceeding. And four, the court finds that the findings are adequate to support the closure. So at this time, the audio portion of this hearing is going to be closed. And just for the record, we do not have any other individuals outside officers of the court who are present in the courtroom. public. Let's see. Ah, yes. Okay. I just read the fact, some facts on this case. Okay. And bond was at 750. We're gonna leave it at, based on this here, that would probably be the, now, still having a difficult time, trying to gauge, your ability to make bond. Let me ask you this here. Are you able to make a $750 bond?
Sir,
Are you able to make a $750 bond?
Yeah.
yeah.
Okay. We're gonna keep, the bond is gonna be at 750. We're gonna find that, you are indigent. However, you are, making an income, even though you do not know what the income is, but you're saying that you have the ability to make that bond. Is that what you're saying?
If I can't reset the court date.
Yes, so you have the, okay. Yeah, so, the bond will be set at 750.
Yes,
Okay.
This is on Mark Smith, where you set his bond at 50,000 on each case.
Okay.
And I was wanting the court to revisit the bond. And
Yeah, but I think we gave you a hearing date. We scheduled you for one, well, let me do this here. What are the, cause numbers on this case? And,
329-008.
hold on. 329008,
329-010.
329010,
329-012.
329012,
329-014.
329014. Okay. Guy's name is Mark Smith. Now let me do Smith. I think you had filed the motion and then we set it for a hearing date. And I was informed by the court coordinator that it was set on a Friday, and you said that you didn't want it set on a Friday. So we gave you another hearing date. That's the last time and that was last week.
Yeah, but I was wondering if there's any way possible we could get him in later on the docket earlier than the,
I don't know. We'll have to look at the schedule.
okay, 'cause
I can't give you just nothing right off the top of the head. I mean, we got some things going.
I understand you,
Okay.
but I was wondering if, we could do, because the hearing date that I was given was May 20.
That was his, oh, you talking about the first one?
Yes, sir, which is a week from Friday.
Right.
And, he's being held under a bond he can't make, and he's in solitary confinement.
Well, I mean, we'd have to look at our schedule to give you a hearing date.
Yes, sir, Judge. I was wanting to know if there's any way we could expedite it.
Yeah, we'll look at that,
Yes, sir,
and see what we can do.
Okay.
State, you have any objections?
No, Your Honor, other than the state was not even given notice of the May 23rd hearing, and,
I think,
It hasn't been set.
I guess she must have talked to you or something. I don't know how it went, but they was
And you know, notice, Judge, the hearing is not set.
Ms. Smith, your, mic is messing up real bad.
I didn't.
It's still messing up real bad. You may have to come in here. No, you're gonna have to come into the courtroom.
Notified because the hearing is not set. The date wasn't good with Mr. Reynolds.
Okay.
So that's why he's here for us to set a good date.
Yeah, okay.
And I told him I had to get that date from you.
Yeah, we'll just have to get back with you on that.
Okay. All right.
Okay, and then what we'll do is, let's do this here. We'll coordinate that with both Mr. Reynolds and the state, because I'm sure they got a schedule too. Okay, well, we'll get back with you, but just make sure we're coordinated with both. Okay. All right. All right.
thank you.
Okay, you're welcome. Mr. Galmore. Okay, we're on the record and cause number 326828, State of Texas versus Latoya Trailer. We have Ms. Trailer who is appearing via Zoom. Ms. Trailer, you could take your mic off of mute. Okay, Ms. Trailer, how are you doing?
Good morning. I'm okay.
That's good. Ms. Trailer, you're here appearing via Zoom. Your attorney, Mr. Galmore, is present in the courtroom. Mr. Galmore, how are you doing?
I'm great, Judge. How are you doing today?
I'm doing fine. Mr. Galmore, you're aware that this trial week is not one of the scheduled trial weeks from our administrative judge.
Yes, Judge.
And so what would you like to do with this case?
It is still a trial, so we'll need to reset it to the next available.
Trial date? Okay, just hold on. Our court coordinator will, you may go in the back. She's having some problems communicating with that mic. Just go in the back. She'll give you a reset. Once you get your reset, you'll be free to go.
Will do.
And Ms. Trailer, stay in contact with your attorney. Your attorney is going to get your case set on the continued on a trial docket. He'll give you your reset. And if this is your only case, you're free to go. And thanks for being patient with us, Ms. Trailer.
No problem. Thank you. Have a nice one.
And you have a blessed day.
Bye-bye.
Okay. You can go in the back.
I have another one. You want to do my other one?
Yes.
I have two more, actually.
Okay, I think you have Brett Graham. Mr. Bailiff, would you please call in, is Brett Graham, let me do this here. Is Graham appearing via Zoom or is he,
Mr. Graham should be on Zoom, and I believe that's Mr. Young right there.
okay. So we're gonna do Mr. Young? Okay. We're on the record in cause number 3266, excuse me, let me repeat that. Cause number 326266. The case is styled the state of Texas versus Emmett Charles Young. Mr. Young is appearing via Zoom. Mr. Young, how are you doing?
Good morning, sir.
Good morning. Now, Mr. Young, you're here represented by your attorney, Mr. Galmore. And Mr. Galmore, you like to make an announcement on this case?
Yes, Your Honor, that's still a trial.
Okay, so it's same announcement. Okay, we reset that one for trial. Now, Mr. Young, please stay in contact with your attorney. Your attorney is going to get a new trial date, and he'll give you that date. This will conclude your case, and you have a blessed day. And also, thanks for being patient with us on Zoom as well.
Thank you, sir. Have a blessed day as well.
Thank you. Okay. Okay, we got Mr.
I have Mr. Graham, but I don't know if that's him on iPhone or not.
I don't know. The gentleman that's on iPhone, would you, or the person that's on iPhone, would you please identify yourself? Oh, that's Mr.
I'm sorry, Your Honor. That was my phone. That was iPhone. I was just disconnect.
Okay. Let's see. We have an attorney.
MS is probably not. Mr.
No,
Graham.
that's Melanie Smith.
Okay, let me see if I can locate him, Your Honor.
Okay.
He didn't answer, Your Honor.
Let's see, call that name again, Rigoberto Pineda.
Good morning, Judge. Rick Canales for Rigoberto.
Yes, was he supposed to appear in person or?
No, on Zoom, Judge. Did I know he's on Zoom, Judge? He's working.
I don't know. Okay, we don't see him on Zoom.
May I have 1 second, Judge? My staff is telling me something.
No,
Yes, Elena?
He's here. He's here.
Yes, I apologize. He's in person. I'm appearing before Zoom with your permission, Judge.
Okay. Okay. Okay, we're on the record in cause number 327782. The case is styled the state of Texas versus Rigoberto Pineda.
Yes, Your Honor.
And is that your full name?
Yes, sir.
How you doing, Mr. Pineda?
I'm not good. What about you?
I'm doing fine. Thanks for asking. Mr. Pineda, you're here represented by your attorney, Mr. Rick
Canales, Judge, for the record.
How are you doing, Mr. Canales?
All right, Judge. How are you doing? Nice being before you.
Oh, thank you. Thank you. Now, Mr. Canales,
yes,
do
Your
you
Honor.
have an announcement that you'd like to make in Mr. Pineda's case?
Yes, Your Honor. I would like to ask for a trial date. However, if the court can give me a status date a month before the trial date, hopefully I can work it out, Judge, and avoid the trial.
Okay, what we'll do, we'll put the case on our pretrial conference docket. Just hold on a minute. We'll give you that date. Oh, that we haven't, our coordinator's having some technical difficulties. Just hold on, we'll get that date to you.
Your Honor, if I may address the court?
Yes.
As long as it's not a July date, Your Honor.
Okay, as long as it's not a July date. Okay, hold on a minute.
Thank you, Judge.
Mr. Canales, the case is gonna be reset to June 21st. Your
Yes, sir.
reset will be faxed to you. Your client has been given a copy of the reset in court.
Yes, Your Honor.
Okay, Mr. Panada, stay in contact with your attorney. You're free to go, and you have a blessed day. And-
Judge,
Well-
may I ask a question, Judge?
Yes,
On June 21st, am I going to be allowed to do it via Zoom?
if it's a plea, you have to come, we have some tablets that have to be signed. You know, if it's a plea, you have to appear in person to sign the tablets.
Okay, yes, Your Honor.
But if it's not, then you can appear via Zoom.
Yes, Your Honor. Okay, just wanted to make sure. If plea in person, otherwise Zoom.
Yes,
For June 21st, Your Honor.
yes.
Yes, Your Honor. May I be excused, Judge?
Yes, you may be excused, and you have a blessed day.
Likewise, Judge. Take care, Judge. Pleasure being in front of this court.
All right, thank you. And you have a blessed day as well, Mr. Panada. All right. Okay. We're on the record in cause number 326-908. The case is styled the state of Texas versus Kira Mae Bennett. Is that your full name? How you doing, Ms. Bennett? That's good. Ms. Bennett, you're here represented by your attorney, Mr. John West. Mr. West, how are you doing?
Doing good, Your Honor.
That's good. Mr. West, you have an announcement you'd like to make in Ms. Bennett's case?
I do, Your Honor. Just a moment ago, before we came in here, she pled to the felony cases. It's been reset for a PSI and for sentencing at a later date. As part of the deal, this misdemeanor will be dismissed. However, I think we should just reset it to that same sentencing date. And that way,
Do you know what date that is?
I do not know off the top of my head, Your Honor. They didn't give me the date. They said they'd send it to me later. But I'm sure it'll be on the computer and I can get with Mel in a moment.
Okay, that's
Make
fine.
sure.
That's fine. Just get with Mel, and we'll get that date. Ms. Bennett, your case is gonna be set on the same day your felony case. And so this will conclude your case. You're free to go. You have a blessed day. And Mr. West, is this your last case?
I believe it's the only case I had in your
Okay,
court today, yeah.
well, you're free to go as well.
Yeah,
Just get with
let her
Ms.
go, then I'll go to
Smith.
talk to Mel.
All right, you have a blessed day.
call your honor, Scholar Mitchell is here now, Mr. Adams.
What, okay, what, okay. You go ahead and get Mr. Mitchell in here. Yeah, Mr. Mitchell is here.
Yeah, that's pre-trial version.
Oh, okay.
Skylar Mitchell.
Oh, okay.
If I'm not mistaken, she signed the contract. I believe so.
Ms. Mitchell? Okay, we on the record in cause number 324308. This case is style of state of Texas versus Skylar Mitchell. Is that your full name?
Yes, sir.
How you doing, Ms. Mitchell?
Fine.
I'm doing fine. Thanks for asking. Ms. Mitchell, you're here represented by your attorney, Mr. Langston Adams. Mr. Adams, how are you doing?
Doing good, Judge.
That's good. Mr. Adams, you have an announcement for the court in Ms. Mitchell's case.
Yes, I believe she signed it. Didn't you sign your contract with pre-trial version?
I signed my contract, I started my anger management, and I've made 2 payments.
Yes, she sent pre-trial version.
Last
Okay.
month.
It's with the anger management.
Yeah, I think we normally reset these like
Mhm.
4 to 6 months out or something like that.
Yes, yeah.
Because the program is, I forgot how many sessions, like 18?
17 or 18.
Yeah, about 18. So we figured if we do about 6 months, that should cover it. Okay, now, Mr. Adams, we having some computer, some technical difficulties with Ms. Smith. She's in her office. You can go in there and get the reset. And Ms. Mitchell, once you get your reset from your attorney, you'll be free to go and you have a blessed day.
Thank you.
Thanks, Judge.
Okay.
And on the other one, I think Mr. Adams needs to talk to his client, so we'll just need a minute before we call Mr. Adams on the
Okay.
case.
That's Hardesty, right?
Yes.
Okay. Okay, that's the dismissal.
Thank you, Judge. You leave it.
Yes.